Good morning, good morning, good morning. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels, and merry stupid o'clock to one and all. We are going back to that horrible world known as the JRC, but before we get going here, the usual disclosures. First off, you are going to see the link to this 1988 settlement agreement, also known as the infamous consent decree, right there in the description box, alongside the massive archive that was put together by Lydia Brown, aka Autistic Hoya, where you will find the majority of the documents that we are using on this channel in regards to the JRC, multiple cases and issues. You're also going to find the templates. Sign your name, click on your senator. Let's end adversive punishments and improper restraints. These kill people every year, folks. Please sign it. We also have the ever-present change.org Shut the Judge Rotenberg Center Down petition. Sign and share on all your social media. Now, when we are speaking about the JRC, you're going to hear vivid descriptions of, as well as sometimes sketch clips of video surveillance footage of, peoples with disabilities being tortured and abused. If you have young children present, please use your headphones. And folks, it is 3:23 a.m. stupid o'clock in the morning. If I mangle my words absolutely horribly at this point, my apologies in advance, and I do apologize on the behalf of my hair. It's been raining for 3 days, folks. I can't do anything with it. So you just have to deal with my rat's nest this morning, all right? Alright, so we're going back to where we left off yesterday. Notifications by OFC to school districts, approval agencies, placement agencies, and licensing authorities. Now, folks, if you want to have any idea what we're talking about, please watch the first and second parts in regards to this consent decree. The JRC has been using it since 1988 to justify their abuse of torture of people with disabilities. Could have swore I muted the TV. Anyways, to where we were. Okay. Upon execution of this agreement, OFC shall send a letter in a form approved by the parties concerning the resolution of this controversy to the following: the special education directors of all Massachusetts public schools districts. So back then, apparently, they weren't even meeting education guidelines. Interesting, isn't it? All committees on the handicapped in the state of New York, the Massachusetts Department of Education, the Rhode Island Department of Mental Health and Mental Retardation. God, you can tell how dated this is just by the names of the departments. The Rhode Island Department of Education, the Rhode Island Department of Children and Families, any out-of-state agency which approves placement of any client at BRI, any out-of-state agency that approves placement at JRC. I have to wonder, what in the name of God, what crack are you smoking? Especially back then when the abuse was, you get what I'm saying. It's still horrible. The GEDs are absolutely horrible. You know where I'm getting with this here. Any public school district or placement agency which funds any part of the tuition of any BRI client, the Massachusetts Department of Mental Health, a reasonable number of additional individuals or entities whose name and address is provided to OFC by BRI within 10 days of the date of execution of this agreement. The defendant shall send a letter to all BRI parents in the form attached hereto. Yes, because their pamphlet is so forthcoming. You remember when Cheryl McCollins talked about the pamphlet that they sent out, which is supposed to be in accordance with this agreement? Yeah, they didn't really cover anything. And they downplayed the type of treatments that they did have. She found out after the fact how horrible this place was. So their pamphlets are incredibly inadequate and doesn't really give any parent or guardian any real idea of what exactly is truly going on behind those closed doors. But I digress. These people, they snow even the judges into making them think that they're legit, so. Agreement concerning attorney's fees. Upon execution of this agreement, the parties shall enter into agreed judgment for attorney's fees in the amount of $580,605.25, payment of which shall be full satisfaction of all monetary claims in this action. The defendant agrees that, through statutory procedures, she will request the legislator to appropriate the funds to satisfy the judgment through an FY 1987 supplemental budget. The defendant shall use her best efforts to secure appropriation. In the event that the legislator declines to appropriate the funds, nothing in this agreement shall prevent the plaintiffs from using whatever legal fees are available to enforce the judgment, and if necessary, to modify the terms to include the personal liability of the defendant. By entering into this agreement, BRI does not make any acknowledgement as to the adequacy of the attorney's fees for rate setting purposes. Why am I not surprised? Why am I not surprised that the BRI, now known as JRC, used funds as a means to beat down any opposition? I am not surprised at all. Kind of sounds like another case we go over on this channel, and a certain nameless one, doesn't it? Just saying. Withdrawal of all litigation and execution of releases. Upon execution of this agreement, all pending administrative and judicial actions, with exception this action and the pending guardianship actions, shall be dismissed with prejudice. So, in other words, they use this agreement, this consent decree, to basically crush anyone that calls into question their torture of people with disabilities. This is why we've had to go federal, folks. This is why we've had to go above Massachusetts' head so many times, because they use this consent decree to beat people in submission. They use money, they use all kinds of things. Upon payment to the plaintiffs of the attorney's fees referenced in paragraph H, the parties shall exchange mutual releases in a form to be negotiated by counsel, and all monetary obligations of the defendant to the plaintiffs shall be discharged. The parents and guardians agree to hold the defendant harmless from any causes of action, including, without limitation, any action under CLC 258, which arise from this agreement, accepting the breach of this agreement, and hereby release and forever discharge subject to the provisions of paragraph OFC and the defendant in her official and individual capacity from any and all claims which arise from the actions of September the 26th, 1985. This is how they got away with murder. God. Form of the agreement. This agreement shall constitute an order of the Bristol County Probate and Family Court in the case of Behavioral Research Institute et al. Versus Mary K. Leonard, civil action number 860018. Some of that's whited out. The rights of all parties shall be limited to enforcement of the terms of this agreement. The court will retain any continuing jurisdiction over this action until such jurisdiction is terminated in accordance with the provisions of paragraph K, at which time an order of dismissal of this action shall enter. During the pendency of this agreement, any dispute between the parties that cannot be resolved by the general monitor shall be submitted to the court for resolution. Periodic review. The probate court shall conduct a hearing at 6-month intervals in order to review the parties' adherence to the provisions of this agreement. This agreement shall be automatically extended at the first 6-month review unless the court, upon motion by any party, orders otherwise. This agreement shall automatically terminate at the second review unless the court, for good cause shown related to the terms of substance of this agreement, orders otherwise. Upon the termination of this agreement, BRI shall continue to employ substituted judgment procedures as ordered by the court. Good faith. The resolution of this matter depends on the good faith of all parties, and each party shall discharge its obligations under the terms of this agreement in good faith. Now, let me ask you a question, folks. Do you think that the JRC has met their side of this agreement? I don't think they have, but I think they get away with it. Because they still have everyone out in Massachusetts convinced that this is the only treatment that works, in spite of how much treatment plans and pharmacology has advanced since 1988. All right, so we got a little bit more to go here. The Behavioral Research Institute, Inc. versus Mary Kay Leonard, individually and in her capacity as Director of Massachusetts Office for Children. Order. It is ordered that the settlement agreement filed with this court on December the 12th, 1986, is hereby approved as it is fair, reasonable, and adequate. Really not. Really not. Judge from 1986, just saying. It is further ordered, and by the agreement of the parties, that the parties shall be bound by the terms of said settlement agreement and by the court's findings of fact and conclusions of law in support of approval of settlement agreement pursuant to Mass. R. Civil P. 23, which are incorporated by reference and made a part of this order. 2. The defendant, Mary Kay Leonard, individually and in her capacity as the Director of Office for Children, shall pay to the plaintiffs the sums of $580,605.25 in satisfaction of all monetary claims. Think about it, folks. The fact that she dared go against the BRI, they beat her into submission. Back in, this is like made final, 1986, 1988. Think about that. Think about it. This is how they win. This is how they win. Because the ordinary Joe is not going to be able to bring up to bat the thousands and thousands and thousands of dollars it takes to fight these people. They win in settlements just like this one. Just like they did Cheryl Collins, what they forced her into. 3. The court shall retain continuing jurisdiction of this cause of action. The parties shall request a general review in 6 months. And this settlement is what they use to scare the freaking state of Massachusetts into reinforcing them every single year, by the way. The parties shall request a second review in 1 year. After the second review, this agreement shall terminate and the court shall issue a judgment of dismissal unless the court orders otherwise. John Dagnall is appointed monitor, reporting to the court, and shall undertake general monitoring of BRI's treatment and educational programs as described in the settlement agreement Part B. All right. Motion to amend settlement agreement. The Department of Mental Retardation, DMR, God, this is old, a successor to the Department of Mental Health, moves to modify the settlement agreement by the court on January the 7th, 1987, as follows. The deletion of the Department of Mental Health, wherever appearing in the settlement agreement, and insertion of Department of Mental Retardation. God. The modification of paragraph A7, third sentence, by the deletion of the third and fourth sentences and the insertion of the following. Prior to the hearing, a treatment plan for a new or current student as called for in that student's clinical circumstances, except that DMR clinician shall evaluate the student if the court determines such evaluation is necessary to consideration of the proposed treatment plan. And yet all just continue to agree to have people with disabilities tortured. Again, thank God I didn't grow up in Massachusetts. I never thought I'd say that. If DMR conditions evaluate a student's clinical circumstances pursuant to this paragraph, they shall provide the court with their recommendations on the issues noted in the Action 6 above, as well as their assessment of the student's ability to provide informed consent to treatment. In other words, we're going to declare you incompetent and stick you in this place anyway. DMR moves to modify the settlement agreement as set forth above for the following reasons. First, on July 1st, 1987, by virtue of Statute 599 of the Acts of 1986, DMR assumed the legal responsibility for licensing the Behavioral Research Institute previously held by DMH. Oh God, and you let it continue? DMR, as the successor to DMH, acknowledged that it has also issued DMH's obligations under the settlement agreement and believes that the agreement should be modified to clarify this point for the benefit of the parties in the court. Second, as the successor to DMH, DMR is mindful of its responsibilities, both under the settlement agreement and under the CLC 19B, Section 15, as the state licensing agency with jurisdiction over BRI. After more than a year of review by DMR Licensing Division, a decision on BRI's application for licensure is imminent. DMR is now encountering practical obstacles to continuing its clinical involvement in each and every case, as 2 of the 3 DMR clinicians are unable to continue in that role. However, DMR stands ready to provide clinical advice to the court in any case or in any issue the court may request. For the following foregoing reasons, DMH respectfully requests that its motion be allowed. And here we go. All right, folks, we got one more page, but I'm going to go ahead and close out for this morning. So my question is, as we get towards the end of this particularly short series here, do you think JRC actually fulfilled their side of this agreement? And that they are doing and following all the law according to this settlement in good faith? I don't think so. Because the JRC has really done nothing to show any alternative treatments or treatment plans other than their own adversive punishing disabled people for being disabled. Since 1988, treatment plans, especially for people like me who are autistic, has grown in leaps and bounds. Let's not even talk about how far pharmacological studies and medicine has advanced since then. But since then, the JRC's arguments for the way that they treat people have continued to be the same. They have not allowed for any new ideas to be introduced. any new treatment plans, none of it. They give a token try for like the first day or two for their so-called positive behavioral reinforcement plan. They then will actually use behavioral lessons to trigger behaviors and then use those behaviors as an excuse to begin adversive punishments. And when those adversive punishments get the student to act out even more, then they use that as an excuse to put the student on GEDs. So, I do not believe that they have acted in good faith in regards to this settlement. The question is, though, who would have the money to fight this kind of monster conglomerate? They have it. We've already looked at the Judge Bernstein's decision where they've got their hands and their money everywhere. You would need some parent or somebody on the spectrum with a good deal of cash to be able to fight these people in the courts and actually not have to settle out of court. This is how they have won time and time and time again. They've really found, when they moved out Massachusetts, the state that will just bend over backwards to protect them in spite of how horrendous they are. So what is the answer here? This is why we have to go over their heads. This is why we had to go to the FDA, why we had to go to the UN, why we had to get the world to focus on this place, why we need national and international pressure. Because literally, nothing else has worked. Nothing else has worked. And to this day, we need that pressure. It has been us and the disability rights and autism rights, neurodiversity rights communities, and the parents of the survivors of this place who have held up this fight for over 30 years. We're tired, folks. We're tired. This is why we need help. So please share these documents. Go on there. Fill out the templates. Sign them. Tell others about this place. Okay? The more pressure there is, the more likely we can finally get the federal government to act, since nobody else has the money, the funds, or the power to be able to do so. And on those notes, I'm going to go ahead and close out for this morning. We don't get very many views on this channel, especially on this subject. The few that we do get do tend to get removed from time to time. So folks, please don't forget to hit that like button, hit subscribe, don't forget to hit the comments. I do appreciate your time this morning, and as always, we here at Spilling Tea hope you have a good one. Bye-bye.